Thank you, Mr. Chairman, and I want to thank our guest here this morning, witnesses, for your testimony. Obviously, we're in a different world today. It's changing rapidly. It's changing drastically in my 40-year business career. And in fact, when I talk to heads of unions, the biggest problem they have is recruiting a workforce, which is the biggest problem we have as employers, is recruiting a workforce. And so there's tremendous competition for workforce out there today. When I started in business, people were standing in line for a job. And I'm talking union people were standing in line for a job. In fact, we would hire groups, and then if they didn't perform, we would send them back and get somebody else. I mean, it was, you always had several people there standing in line. That is not the case today. And of course, the franchise model has created tremendous wealth. And in fact, in my experience in business, where we self-perform most of the work initially in the construction industry, now we subcontract 95% of the work to union members who are now entrepreneurs running their own businesses. Every one of them came up through some type of apprenticeship program. So they're not liberal arts graduates. They came up through the apprenticeship program, and they're entrepreneurs, and they're doing quite well. Mr. Haller, as you're well aware, the Biden Department of Labor is currently seeking to finalize an unclear and overly restrictive independent contractor rule that would make it significantly more difficult for individuals to work as independent contractors. And it would have a devastating impact on millions of workers and thousands of businesses. Additionally, we've talked about this, the radical NLRB has recently finalized a rule to adopt a more expansive definition of joint employment. How would the independent contracting and joint employment provisions of, you had mentioned the Employee Rights Act, which we authored, impact the ability of American entrepreneurs and workers to climb the socioeconomic ladder?
Thank you, Mr. Allen, for the question, and thank you for your leadership on the Employee Rights Act. As you mentioned, the provision in that legislation that we strongly support would allow for franchising to continue to thrive. And we have countless stories in franchising where workers have gone on to eventually become franchise owners themselves. And our issue with this discussion and these issues is really not with unionizing. You can have collective bargaining, but you can also, without having a broad joint employer standard, right? You just can't have joint employer and franchising. They cannot coexist. The joint employer provision in the Employee Rights Act would allow people like Tam Kennedy, who I talked about in my testimony, and countless others, to go from the entry level to become franchise business owners and get that support that franchisees say that they need from the franchisor to become and stay successful small business owners. We appreciate your leadership and the committee's leadership on that issue.
Mr. Vinicio, did I pronounce that correctly? Close.
You did. Thank you.
Good. All right. In August, President Biden's NLRB gutted workers' rights to decide union representation by secret ballot vote by issuing a decision to make it easier to conduct card-check union campaigns. Do you think card-check elections create an unfair election environment?
Thank you for the question, Mr. Allen, and thank you for your leadership on the Employee Rights Act. To answer your question, no, because there is no election environment. Card check bypasses an election and allows for unions to have an open, basically, petition process. Unfortunately, with the PROAC and with the CEMEX decision, unions still can tell employees you will have an election, but then the rug is pulled out from under the workers. And even though they have an election, unions can say, well, there was an unfair labor practice or the employer violated a portion of election law, and say recognize us via cards. And with the new CEMEX decision, the NLRB could then recognize the union. This is why your provision in the Employee Rights Act is so important.
Yeah, and the secret ballot is a long-time important tool in our culture. And as far as the currently labor unions have essentially unchecked access to workers' personal information, are you aware of examples where labor unions misuse workers' private information? How would the Employee Rights Act help to put a stop to this occurring? We got 9 seconds.
Yes, there's been testimony in this committee on unions harassing workers at home, repeatedly coming even after the worker says, please do not come to my house. The Employee Rights Act would protect workers' privacy by giving them the option to choose what piece of personal information to give unions. So, for instance, if they did not want a union coming to their home, they could say, just email me.
Good. Thank you for your testimony. Chairman, I yield back.